when you have more than one person living in a place, issues of dispute are about to happen. And that is where laws have been formed as we now begin to have larger societies. We begin to see laws in a way that they will also form a body that will help to adjudicate issues that may be arising from disputes. And that's where the society comes in, and that's where the judiciary also fits in. And that is the essence of having Law and You program set out for you to get more knowledge about how concepts in this regards can be elucidated. And my name is Philip Omo Gyupo. With this, I say welcome to a fresh episode of Law and You. Today we're going to be looking at the rights of the accused persons and procedures and what comes into play when someone is accused. And does he have the right to, get a lawyer in court so that he can help to adjudicate his or her case? You're going to be getting all of this on this episode, sponsored by Noah Attorneys, a legal firm based in Benin City, Nigeria. My name is Philip Omo Gyupo. Joining me on this journey to elucidate this in this direction is a human rights activist, a constitutional lawyer, Alakwe Mbanefo. Thanks for joining, Alakwe.
Good afternoon, viewers.
What is the meaning of when you say somebody is being accused, and what are the inherent rights?
Yeah, in a simple language, a simple definition, an accused person is someone that commits crime. Someone that commits crime, being a man or a woman that is alleged to have committed a particular crime. So who he is becomes an accused person. But then, in the new law, Administration of Criminal Justice Law, we no longer refer to people that as accused persons. Okay. So the new law now refers them as defendants. Defendant, because the previous name, accused person, being used in ordinary parlance, is already suggesting that that person, is accused or is already convicted. So, Administration of Criminal Justice Law now sees such a person as a defendant.
Okay. What about
so it can be a suspect. Okay. At that point. It becomes an accused person when he's been convicted by a court of competent jurisdiction.
Okay, so by what you just said, when you say somebody is accused, it means that person has been convicted.
Yes.
By a court of
competent jurisdiction. Yes. Yeah.
Okay, let's go in that fashion and let's get to see what are the inherent rights of an accused person if he has been convicted. Does he have the right to function in some abilities, like maybe right to a lawyer, or right to, because if he's convicted, it depends on what court convicted him, and if he has the right to appeal the case so that he can seek a redress, or if he has a right to be bailed depending on the nature of the charge against him.
Yeah, right from the time a defendant is alleged to have committed an offense, and to the point at which he's taken to court, still as a defendant, the Constitution of Nigeria, the 1999 Constitution as amended, clots that particular defendant with a whole lot of rights. For instance, the Constitution of Nigeria, have this particular provision that every accused person is presumed innocent.
Exactly.
Until proved guilty by a court of competent jurisdiction.
Okay.
So that means the 1999 Constitution as amended inures in favor of the defendant.
Okay, you just give me some fresh air, because I was almost stuck when you said about the accused persons, already proven guilty, because I was almost thinking, where does the suspect come in? But let's come from this perspective you just highlighted. A situation where one is seen as a suspect, for instance, and he has some rights, you know, because he has not been proven guilty yet until the court or the court of competent jurisdiction, you know, does otherwise. At what point can he get his rights, you know, enjoyed?
Yeah, and a defendant in Nigeria, you know, like I said, is clothed with all the rights of even a person who did not commit any offense, you know, by virtue of the Constitution. The Constitution is the ground norm, and the presumption of innocence, that privilege is enjoyed by a defendant or a suspect, as you may call him, right from the time he's been arraigned to the time he's being convicted.
Convicted by a court of competent jurisdiction.
It's only when he's convicted, you understand, that he falls on the other way side. That's now a convict. But even at that point, he still enjoys that right.
He enjoys the right.
Because he has right to appeal
exactly.
against that judgment if he is not,
in his favor,
satisfied by the ruling or by the judgment of the court.
Okay, so which means at the point where he is being convicted by a court of competent jurisdiction,
yes,
and he wants to appeal the case, whatever comes with the judgment of such a court, he can also enjoy the right to be granted bail. Or at what point can he not enjoy that?
Yes, at that point, he can still be granted bail.
Or even before he gets to court?
I don't understand it. Before he gets to court?
No, at the point where...
No, I'm talking about when he's already convicted. If a court has already convicted him...
Oh yes, even if he has
right to appeal.
He has right to appeal.
Right to appeal.
At that point of even have the right to appeal, does he not enjoy the right to, get bailed?
Why not? He can get the right to get bail pending appeal.
Or pending on the offense committed.
Pending appeal. You can get right to get a bail pending appeal. A situation whereby the court has the discretion. The appellate court or even the lower court, of course, has discretion to grant bail or not to grant bail pending the outcome of the appeal.
Okay, but what are the cases? Because I'm looking at the nature of the cases that could give room for a court of competent jurisdiction to allow bail for one though who has been convicted but has not sought for an appeal. So at what point can such a convict from the lower court or whatever, or court of competent jurisdiction, is granted bail even after the first judgment?
Yes, apart from the matters that have to do with capital offenses.
Okay.
Like the case of murder and some very serious offenses that where the court will be reluctant to grant bail because of the nature of the offense. Every other matter, as long as the person has a reliable surety, the court can always grant bail. The court can be reluctant to grant bail. Where offenses committed is a capital offense, like in the case of murder and otherwise.
Okay.
But outside that, what the court looks at is whether you have a reliable surety. Once you have a reliable surety, the court can always grant bail.
Even if it's a capital offense or
where it is not a capital offense.
Okay, but a situation where, because it's already in the purview that, in public domain, I mean, that it's even better to release 10 persons that are guilty than to allow one person to suffer who is innocent, So in that case, if one has a charge against him that is seen as a capital offense charge, isn't it right for the law court to x-ray such cases and make sure that such a person is not charged unduly, and then by virtue of that, look within and see how such a person can be granted bail, even though the charge against such a person is capital?
Yeah, the trial of the journey in a criminal trial starts from the police station.
Okay.
Or any other agency whose duty is to investigate matters and then take cases to court, like EFCC, like ICPC,
the law enforcement agents,
like DSS, and then the police. And so These bodies are left with the responsibility of investigating a crime that is allegedly committed by a defendant or a suspect. Most times, the offshoot of those investigations, is always determined by if these bodies is convinced that the crime has been committed. The suspect is now charged to court, and the rest is left for the court to determine. And as part of the rights of the defendant or suspect, the suspect or defendant has right to hire a lawyer, a counsel, who is going to, of course, defend him. Let me say this, that in a criminal charge, you can't convict a defendant or a suspect without legal representation in court. And most times, where the suspect or defendant can't afford a counsel, most times the judge can, ask the lawyers in court to volunteer to defend the suspect or the defendant. And most times, lawyers has always volunteered to defend them, where there's no, they can't afford to hire a lawyer. And there are also some other establishments that deal with such cases that don't charge any money, that can also defend the suspect or the defendant. And so, because the law is clear that you cannot convict a suspect or a defendant without legal representation.
Okay, well, you said this is quite awesome, amazing, but that also leaves us with the shock and the unfortunate incident of a lot of persons who are even behind bars without their case even be called up in the law court. If you go to prisons, for instance, you're going to see so many persons whose case have not even been called in the court, and yet they are already in jail.
Yeah,
how do you see that?
Those cases...
Is that right of the accused or the suspect protected?
No, the suspect, like I told you, has right to legal representation.
Yes.
If he can afford it.
Okay, if he can't afford it.
If he can't afford it, there is a legal aid counsel. There are lawyers that are working with legal aid counsel.
Isn't the state supposed to... Isn't the state supposed to offer this?
The legal aid counsel...
Rather than allow them to, be in jail or without being heard?
The legal aid counsel renders free legal services to such suspects or defendants who does not have the wherewithal to hire an attorney.
Okay, so what you're saying is that those who are accused or those who are seen as defendants or as suspects are at the mercy of being found by this group of persons that don't really charge. Is that what you mean?
Yes.
If they are at their messes, it means a whole lot who have not been able to be found by such bodies will languish in the cells. And so how does the state or how does the government compensate for such lapses when eventually they are found to be innocent?
It's the duty of the correctional centers, officers at correctional centers, to pencil down the names of such inmates who cannot afford legal representation, and then present those names to legal aid counsel. Legal aid counsel is always going to courts, and they are always doing their matters.
Okay, so if they fail in that duty and responsibility, who checks?
No, there is no way. Recently, the government has also made provisions for magistrates who goes to prisons and goes to police stations to check on the status of the prisons. Okay. Those who have such representations.
Okay, but if we have that in place, like you just said, how come we're still having these lapses and the large or huge gap that seems unclosed?
The system is taking care of those lapses because recently, most times, the Attorney General of the executive, either they pay them, or sometimes they still do it pro bono.
Okay. Well,
when the lawyer is doing a case pro bono, that means he's not charging any money for that case.
All right. In case you just came to find out, the show is Law and You, and we are on the topic accused persons and rights and the procedures in order to enforce these rights. And I've been speaking with a human rights lawyer, and he is a constitutional lawyer also, and he is Alakwe Mbanefo. Thanks for sustaining your presence here. Okay, well, let's go a little bit further, or let's start from the scratch of arrest.
Yeah.
Now, we've seen situations where, let's start from the scratch, where an arrest is made, and then the law enforcement agents engages the suspect and say, you have a right to remain silent, or else whatever you say will be used against you in the law court.
Yes.
Now, when such an arrest is made, how many hours should such a person remain in the custody of the police before the case is charged to court?
Yes, the law says 48 hours.
48 hours.
Yes, the person must have been charged to the nearest court, closer to the place of arrest, or to the police station. Yeah, but if the police is unable to conclude their investigation
in 48 hours, it can be extended.
It can be extended.
How do they do
that? They have to go to court
to obtain that.
To obtain an order, at least 14 days, to enable them conclude their investigation, but not more than 14 days.
Do we see that?
Yes.
Okay. Now let's stretch it a bit further. We have situations where jungle justice becomes the order of the day, because a lot of people see that when it comes to administration of justice, they seem to be failed by the authorities in question, where they see somebody who really committed the act, and before he's taken to the police station, he's beaten black and blue. And then you see a situation where the people, take this person that has been beaten up because he was caught in the act and he even confessed to the crime, taken to the police station. Then the police will refuse to admit such a person in their custody and say that the people that brought him should get him treated. And after getting him treated, should get him fed. And after getting him fed, should get him money and discharge the case without even arresting such a person. There are incidents like that. And even the one that I even personally, witnessed. Now, what do you say about this? Do you see such rights as fair enough to be enjoyed by such suspects who are not really suspects but are seen committing the act?
Yeah, the law is very clear. The law doesn't allow you to resort to self-help
or make a personal judgment.
Yes, so jungle justice, is never supported by Nigerian law. Jungle, no citizen of this country has the right to resort to self-help or take laws into his or her hands. You don't do that. If somebody is caught committing a crime, the only thing you can do is to get the person and hand him over to the police. It's left for the police to look at the offense committed and charge the matter to court.
But don't forget the aspect of anger, for instance, when you get somebody committing the act. Don't forget the aspect of anger, and that's how justice originated.
No matter how,
a situation where you saw somebody in the act, and you know the challenges that we face, even in the economic hardship that we're faced with, it's not easy for one to get even a meal, not to talk about a square meal. And then you see somebody who is stealing from your possession. Basically, it's expected that the people will pass vengeance on such a person by giving him the beating of his or her life. But don't you see it as reasonable for government or law enforcement agencies to close the gap and bring confidence of the people?
Exercise jungle justice. The system is there, and the police that are there, there is no level of anger that can justify jungle justice.
But what about the breach of trust that the people seem not to have in the law enforcement agents? That trust that has been breached, where they think that if they, because I just gave you a scenario that I even personally witnessed, in my area, for instance.
Yes,
the issue where such a person was caught in the act, and even confessed to the crime, to the people, and he was beaten. But at the end of the day, he wasn't even in the police custody because the police refused to harbor him. How do you explain that? Do you see that as a system that wants to correct? Wait. Do you see that as a system that wants to correct the ills in society, or that wants to bring the aspect of jungle justice to its barest? Because at the point where the government is failing in its responsibilities, or the law enforcement agents are failing in their responsibilities, it gives room for an increase in jungle justice.
The citizens of a country like I said, no matter the circumstances, has no right to arrogate to themselves the powers of the police. There's no excuse that is good enough, that is acceptable for why someone should arrogate to himself the powers of law enforcement agents.
Okay, but if the police, for instance, fail in their responsibility, what should the people do?
If the police...
Like the scenario I just told you.
The first in their responsibility...
Petition?
In their responsibility. There is a particular arm of the police that deals with the police.
Okay. So they have to petition?
No.
Okay, how do they do that?
If the police first in their responsibility, and how do you even conclude that they have failed their responsibility? If you think...
One is not taking a suspect to custody for interrogation. It's a very clear case of a lacuna, or a clear case of a gulf or a gap that should be closed.
If you feel that police has failed their responsibility, you can write petition to the Commissioner of Police, complain about what you presume as failure of the police to have done their job, and the Commissioner of Police will look into it.
Okay, I said that because sometimes it's quite an Herculean task in the process of making a petition. And when you are now making the petition, where is the suspect? Is the suspect in the custody of the police or in the custody of the people? So how do we arrest that ugly incident? Because you are saying make a petition. But in the process of you making a petition, the suspect in question is at large. So do you see this system as a workable system?
It is a workable system, because without the laws and the police, this place would be an animal kingdom. So without the police and the system, the judiciary, the law enforcement agencies, you cannot sleep quietly in your room. So it's working. Of course, there's no perfect system, but it's working. The fact that there's sanity in the society is because you have the law enforcement agents and you have the judiciary. Without these two bodies, that means this place will be a lawless state.
Okay. Let's go to about the capital punishment you made mention of. Take, for instance, one is already accused and convicted, and he is made to face the law by maybe prison sentence for life or death by hanging. What exactly are the provisions of the law codified in the Constitution of Nigeria, in the 1999 Constitution as amended, that spells out the right of someone who is already convicted? Yes, most especially if it has to do with capital offense.
The person has the whole right as endured in the 1999 Constitution as amended.
Those rights, when he's being faced with death sentence,
those rights endures
what right when he's being faced with a death sentence?
The right, he has the right to appeal.
Oh, no. If that is exhausted,
okay,
at the level of
the Supreme Court,
yes.
It's only way it can be. You can say that it's exhausted.
Yes.
But whatever is the pronouncement of the Supreme Court is final. So it's such a matter if the Supreme Court, having looked at what transpired at the lower court, was convinced that the judgment of the lower court is perfectly in order and it is upheld, that is the end of the matter now.
Okay, so such a person loses all the rights.
Yes.
We've seen situations where some will be asked how they want to die. Because if it's death, if it's death sentence, and then some will say, well, death by hanging, or what other means, or such a right isn't allowed for such a person.
Yeah,
to determine how he or she wants to die.
In Nigeria here, it's death by hanging.
Okay.
Then it's under the military administration.
So no options. No options.
Under the military administration, you can execute.
Okay.
Execute the criminals.
Okay.
Then under this administration is death by hanging. But in the civilized climate now, it's life sentence.
Life sentence.
Life sentence, because they have a feeling that nobody have right to take life.
To take life.
So it's once you get to that level, it's life sentence.
Thank you for taking out time to be part of this, and we hope you oblige us in subsequent editions of Law and You.
I will always do that if the time permits.
All right. Well, you react to the numbers on the screen as we have it there. And don't forget, this program has been sponsored by Noah Attorneys, a legal firm based in Benin City, Nigeria. I am Philip Omo Gupon. We'll see you on the next one. Goodbye.